everyone. This is Professor Swati Tyagi, Assistant Professor at IMS Ghaziabad University Courses campus. Today I'm going to talk about the Employee Compensation Act 1923, which is the first social security measure taken in India aiming to provide workmen some relief in case of an accident or an injury at the workplace. Employees are an organization's pillar of success, and it falls upon the employer to ensure that their workforce receive proper financial compensation assistance in case they met with an accident or an injury at the workplace. With the advent of industrial revolution and harnessing the power of steam and electricity, the dangers at the workplace increased manifold. To ensure proper compensation in case of fatalities, several laws like Compensation Act 1884 and Fatal Accident Act 1885 were implemented. However, they were not enough to financially compensate workers in case they met with an accident performing their duties. Hence, the Parliament passed the Workmen's Compensation Act 1923. Let us look into the background of this act. So, when India was a British colony, under the British rule, common law was followed in case of compensating workmen for injury or death. As per the common law, it was the responsibility of the workman to prove in the court that he has got injured while working at the premises, and it was the failure or fault of the employer, and then he could claim the compensation, which in itself was a humongous task because the workman had to go through a long and costly process of litigation in which the odds have heavily weighed against the worker. But after the act, the compensation became automatically due, and the employer had to prove the negligence of workmen to avoid the payment. This change was a result of the act, and as it has reversed the position under the common law to a large extent. The Employee Compensation Act of 1923, initially referred to as Workmen Compensation Act, was introduced by the British Indian government to cater to the requirement and entitlement of workers who suffer injuries or disabilities as a result of accidents occurring during their employment. That is, accidents arising out of and in course of employment, which means the accident should happen at the premises while the worker is still performing his duty as assigned to him. So this law was a direct response to the Industrial Revolution and the rising occurrence of industrial accidents in the early 20th century. Let's look at the structure of the Act. This Act has 36 sections in it, 4 parts and 4 schedules. The Schedule 1 is again divided into 2 parts. Part 1 contains the list of injuries deemed to result in permanent total disablement. Part 2 contains the list of injuries for permanent partial disablement. So if you can see, the act has everything prescribed in it. So when you are about to calculate the compensation, you just have to look at the schedule and look into the injury, and you would be able to calculate the compensation which is meant for a permanent total disablement case or a permanent partial disablement case, right? Schedule 2 is there, which contains the list of people or persons who are included in the definition of employee. So Schedule 2 talks about the people who could be considered as an employee. So once you are considered as an employee, then only you become eligible for the claim of compensation. Schedule 3 contains the list of occupational diseases, again in 3 parts. So occupational disease is something which you ought to get, which ought to happen to an employee who is working in a particular manufacturing process. So he is eligible for compensation. For that, it automatically becomes due. Schedule 4 contains the factors for working out the lump sum equivalent of compensation amount. Schedule 4 contains the factor which we will multiply in order to calculate the compensation amount. As I always say, when we look into in a law or a social security legislation, it becomes very important for us to understand the definitions first, because then only we know to what extent it applies. So first comes the dependents, who all will be the dependent of the deceased workman. It would contain a widow, a minor legitimate or adopted son, an unmarried legitimate or adopted daughter, or a widowed mother, partially or wholly dependent on the earnings of the deceased workman. Then comes the workmen, who all will be called as workmen. So it is mentioned here: a railway servant, as defined in clause 34 of section 2 of the Railways Act, a master, a seaman or a crew member of a ship, a captain or crew member of an aircraft, a person recruited as driver, helper, mechanic, cleaner, or working in any other capacity in connection with the motor vehicle. Then workmen employed in any such capacity specified in Schedule 2. All these will be called as workmen for the purpose of the Act. Then comes the definition of disablement. Now this is very, very important, because since we are here to calculate the amount of compensation, here is the definition of partial disablement. What all will be considered under partial disablement? Partial disablement, where the disablement is of temporary nature. Such disablement reduces the earning capacity of a workman in any employment in which he was engaged at the time of accident resulting in the disablement. Total disablement: such disablement, whether or of a temporary or permanent nature, as incapacitates a workman for all work which he was capable of performing at the time of accident resulting in such disablement. So if you can see, total disablement is the kind of injury which incapacitates the workman from doing all the work which he used to do earlier, right? And partial disablement, some capacity would be reduced, some earning capacity would be reduced because of the injury, right? So next comes the applicability. Employee Compensation Act applies to all the factories, mines, plantation, transport establishments, construction works, railways, etc. However, this act does not apply to workers who are already covered under the Employee State Insurance Act. Of course, you can claim the compensation under one of the act, either of the act. Then the eligibility: for a workman to be eligible under the act, there should be at least a causal connection between the death and the nature of duties. So there should be, if the direct connection is not there, then also a causal connection will also make the workman eligible for the compensation. The accident should be arising out of an in course of employment. As I mentioned earlier, the worker should be at the premises working as per the terms and conditions of his employment. Then comes the compensation shall be payable for personal injuries only, and personal injury must be due to accident, not natural death, circumstances, or wear and tear of body. Now, employer's liability for compensation. The employer's liability for the compensation will be automatically there for occupational diseases and also for personal injuries or accident arising out of compensation and in course of employment. Now, under the common law, there were some defenses available to the employer through which he could get rid of his liability of paying the compensation. These are the defenses available to the employer. The first one is doctrine of assumed risk, which says that the employer could argue about the condition that the employee already knew about the risk associated with the employment. Now, since he had joined the employment, so the employer shall not be paying for the compensation. So that was assumed risk. The doctrine of contributory negligence is the second, and it says that the employer could argue that the injury has happened because of the negligence of the employee, so he won't be paying for the compensation. Third comes the doctrine of common employment or fellow servants responsibility. Here the employer could argue that a group of employees had been given a responsibility for a work, and if one of them has faltered, then he won't be compensating them. Then comes the doctrine that personal claims comes to an end with the death of either party. So with the death of the employee, the employer's responsibility comes to an end. And lastly, the doctrine of added peril. So this is again a defense available to the employer under the common law, through which he could just get rid of the compensation liability, paying the compensation liability. Next is when the employer not liable to. So there are certain conditions under which the employer is not liable to pay for compensation. Let us quickly look at those circumstances. The first one is the employee suffers from an injury or accident by disregarding the safety norms, which means if the employee is not following the instructions which are to be followed while working on a dangerous machinery, or if he is not wearing the safety gears and then he got injured, then the employer shall not be paying for the compensation. Second comes the injury resulting in partial or total disablement for less than 3 years. If the injury is just for 3 days and the employee is be able to work after the 3 days, then he won't be getting compensated. And lastly, for accidents and injuries under the influence of alcohol, if the worker is under the influence of some alcohol or some drugs and then he met with an accident, the employer shall not be paying for the compensation. Here comes the part which is the most important part of this act, which is the amount of compensation. How do we calculate the amount of compensation? First comes the case of death. If the employee deceased at the time of injury at the workplace, then an amount equal to 50% of the monthly wages of the deceased workman multiplied by the relevant factor, or an amount equal to 1,20,000 rupees, whichever is more. So as I just mentioned in the earlier slides, that you need to multiply the monthly wages into relevant factor. So here is a table given in the Act, Schedule 4, wherein you could see that the on the left side the ages of the workmen are mentioned, and on the right side the factor. So higher the age, lesser the compensation. So I'll be also explaining it through an example. Let us quickly look into the second category, wherein the employee get permanent total disablement. In that case, an amount equal to 60% of the monthly wage of the injured workman multiplied by relevant factor, or an amount equal to 1,40,000 rupees, whichever is more. Third case is where the employee gets permanent partial disablement. Under this, there are again three conditions. Two conditions are there. So first is if the injury is mentioned in part 2 of Schedule 1, then a certain percentage of the loss of earning capacity will be given to the workman. And second category, if the injury is not mentioned in the schedule, then the amount of compensation, the kind of injury, will be assessed by the qualified medical practitioner, and then the percentage of compensation shall be calculated. Lastly, temporary disablement. For temporary disablement, the Workmen Compensation Act 1923 provides financial compensation up to 25% of the concerned employee monthly wages. So as you can see, there are 4 ways in which we the employer compensates the employee. First one is the case of death, wherein 50% of the monthly wage multiplied by relevant factor, or 1,20,000 rupees, whichever is more, will be given to the employee in case of death. In case of permanent total disablement, 60% of the monthly wages multiplied by relevant factor, or 1,40,000 rupees, whichever is more. Third case is of the permanent partial disablement. In that, there are 2 conditions. First is if the injury is mentioned in the schedule, then a certain percentage of the loss of earning capacity will be given. And second case, if the injury is not mentioned in the schedule, then the medical professional will tell the percentage of loss of working capacity, and accordingly percentage of amount will be calculated. Fourth is when disability is of temporary nature. In that case, up to 25% of the monthly wages of the workman shall be given to him as compensation. So let me quickly explain it to you by the help of an example. As I mentioned, higher the age, lower the compensation. So for example, if the worker is earning 3,000 rupees per month and his age is 23 years old, and he met with an accident, it's a death on the spot, then how do we calculate the compensation? So as I said, 50% of the monthly wage in case of death. So 1,500 will be the 50% of 3,000 rupees. And if we look at the relevant factor, 23, let's look into the table. 23 is equivalent to 219.95. So we shall multiply 219.95 by 1,500. The amount comes to 3,29,000 rupees 935. 3,29,935 rupees. So which is obviously more than 1,20,000 rupees. So this amount shall be given to the deceased workman's family or dependents. I hope this is clear. Moving on, let's look into the controlling authority. Who will be controlling the administration of the act? The commissioner shall be the controlling authority. He shall be appointed by the state government. He could be a member of state judiciary with an experience of over 5 years, or an advocate or a pleader with over 5 years of experience, or a gazetted officer again with similar experience. So he'll be taking decisions on any matters related to compensation or the time duration of the compensation payment. All these matters will be handled by the commissioner. Civil courts shall not have any jurisdiction in such matters. Distribution of compensation, how the amount of compensation will be distributed. So the compensation payable for death and compensation payable for the workmen shall be through the commissioner only. Employer can make advance payments directly to the dependents in case of death equivalent to 3 months salary of the deceased person. Second, employer is exonerated from his liabilities if he deposited the compensation amount with the commissioners within the stipulated time. The commissioner shall call all dependents of the deceased and determine the method for distributing the compensation among them. If no dependents are found, then he shall return the amount to the employer. Or on request of the employer, the commissioner shall furnish the details of reimbursement as well. Next comes the penalty, where an employer is in default in paying the compensation due under this act within 1 month from the date it falls due. The commissioner shall direct the employer, in addition to the amount of arrears, pays simple interest. So if he fails to pay the amount within the stipulated time, he shall be paying the amount along with the interest of 12% or more. Commissioner has the power under the act to impose penalty as well as the interest on the cleared amount as per the provisions of the act. Employer may face penalty for various offences under this act as well. Some of them are mentioned here. If he neglects to submit a report about the accident, or not sending a report of a fatal accident within 7 days, if he is failing to inform employees about their compensation rights, the punishment for such violations shall be a fine, which shall not be less than rupees 50,000 but may extend to rupees 1 lakh. And lastly, the notice and claims. The claimant shall give notice of an accident to the employer or by entering the note in the notice book. Such notice shall give the name. That notice should contain the name and address of the injured person, the cause of the injury, and the date on which the accident actually happened, and submit the claim application to the commissioner. He could do within 2 years from the date of accident. In case of occupational disease, if the worker is injured because of the occupational disease, the accident is deemed to have occurred on the first day of disease. Defects, if any, in the notice or not giving in notice, delayed application will not bar the claim for compensation. So if the claimant is slightly late to file the application, then also he shall be eligible for the compensation. Today, this is all from my side.